the best of money matters. The Big Story.
Welcome to The Big Story. I'm Hongbin Jeong. What happens when a friendship, a financial deal, and millions of dollars collide in court? Taiwan-born Singaporean businesswoman Fiona Lee and her husband are suing their former relationship manager. They allege she was negligent for failing to monitor the price of shares they sold in 2017. At the heart of the dispute is a stock in Toronto-listed Lithium Americas Corp, which later surged in valuation after a consolidation. Her former manager, Lo Kia-hui, denies ever making such promises, while her lawyers argue that this is really just a case of seller's remorse. But what exactly is seller's remorse in the eyes of the court? Can you even sue for it? And how much responsibility do relationship managers really carry under the law? Well, joining us today to share more is Adrian Wee, who's a managing partner at Lighthouse Law. Hi, Adrian. Welcome to the show.
Hi, Hongbin. Thank you so much for having me.
Thank you so much for joining us. Well, Adrian, how strong is the businesswoman's case against her former relationship manager? Does she stand a realistic chance of winning?
Well, that is a case that is live in court at the moment. And, we want to be careful about sort of making comments about a live case. But I would say in general that people have attempted to hold banks responsible in the past. And, it's quite uncommon for the customers or clients of banks to succeed in claims like this.
Well, as you mentioned, previous cases saw people suing against the bank, but Fiona Lee chose not to sue Julius Baer directly, but instead went after her former relationship manager. So since Ms. Lee chose not to sue the bank itself, how does this affect her chances in court?
Well, typically the bank's customers or the relationship between a bank and its customer is governed by, among other things, a contractual relationship. When you sign up as a customer of a bank, you fill out what is usually quite a voluminous contract setting out all these terms between yourself and the bank. And in proceeding against the relationship manager instead of the bank, one of the effects of that may well be that contract between the customer and the bank is not operative. So that gives, I suppose, some leeway in pursuing the relationship manager.
Well, have there been previous cases in Singapore or even abroad where investors successfully sued relationship managers for alleged negligence?
Well, these kinds of claims, successful claims against banks are few and far between. There was, for example, a claim sometime in the mid-2010s where a litigant was actually successful against Deutsche Bank in the High Court. But that decision was subsequently overturned on appeal. So in short, on appeal, the bank won.
Right. Well, then how much responsibility do relationship managers usually bear for, clients' investment decisions compared to the banks they represent?
In most cases, the relationship managers are the arms and legs and eyes of the bank. Banks only deal with customers, or banks deal with customers primarily through the relationship managers. So in most of these claims by customers, when a customer alleges that a bank has been negligent, what they're really saying is that the relationship manager who acts on behalf of the bank has been negligent.
Right. And in this case, the defense has described this lawsuit as a case of seller's remorse. Legally speaking, Adrian, what does that mean and how is it treated in court?
Well, typically, reference to seller's remorse is a reference to a seller having made a bad deal and, is now trying to pin that on someone else. This, again, is not uncommon. We've seen a slew of lawsuits come out of each financial crisis. So in the 97 financial crisis, or in the wake of the 97 financial crisis, there were a series of suits from customers who had lost money, because of investments that had gone bad. Similarly, in the wake of the subprime mortgage crisis and the Lehman Brothers collapse, there were also a series of suits. So it's not uncommon for customers who have made bad investments or lost money through investments to then, with the benefit of hindsight, feel that the banks are in some way responsible for their losses.
Well, as for the defense then, how can they prove that this is seller's remorse?
Based on media coverage, it seems that really one of the most important issues is a factual one, i.e. whether there was a particular meeting in which the relationship manager had agreed to undertake certain responsibilities. So I think that's going to be one of the key issues in this trial. And that's actually a factual dispute. At the end of the day, the court will have to decide one way or another whether, among other things, this meeting did or did not take place.
Okay. Well, conversely, in practice, what types of evidence are most persuasive in proving negligence by the relationship manager?
Well, the primary sources of evidence usually are in the form of communications. So, for example, emails and more recently chats. For example, messaging chats between clients and their relationship managers. In some cases, of course, there will be eyewitnesses to describe certain meetings that may have taken place. Those are the sorts of types of evidence that usually come out in trials like this.
Well, then, how do judges typically distinguish between genuine negligence and simple regret over a financial decision that didn't pan out?
It's usually a factual dispute, as it is in this particular case. I suppose at the end of the day, courts would have to decide, first of all, what happened, right? So what the facts of a case are, who said what to whom, where and when. And then on the basis of that factual determination, the courts will then need to decide whether the application of the law would yield a finding of negligence or not.
Okay. I mean, the trial continues on September 18th. So realistically, Adrian, what are the possible outcomes?
Well, to put it simply, one party is going to win and one party is going to lose. So the court can possibly find a few things. And the two major outcomes, I suppose, are, whether the bank is responsible for part or all of the losses sustained by the client, or whether the client is the author of her own situation.
Okay, so let's say the plaintiff wins. How will the damages then be calculated? Would it be according to the capital loss?
Well, it's difficult to say without, I suppose, a closer examination of the court papers. These damages, speaking in general, of course, can really depend on the nature of the losses. In some cases, for example, there has been a simple loss in value of a particular investment. So say my investment was worth $5 million yesterday and it's worth zero today. Well, then the customer is going to want the refund of that value, right, to be made whole. In some other cases, and we saw this in the wake of the subprime mortgage crisis, what customers did was they tried to invalidate their entire investment and therefore they wanted to have their original investment back. And in still other cases, for example, some customers would say that because of this loss, they've been denied the opportunity of making a certain amount of profit. And so in addition to the value of the investment, they'd be looking to recover the profit that they could have made had this situation not taken place.
Well, then what are the implications if the court sides with the defense instead?
Well, first of all, it would be a significant decision because, as I said, it's quite rare for a customer to succeed in a negligence claim against the banks. But I think if the customer does succeed, and this would apply to any case in which a customer succeeded in a claim against a bank, I think banks would then take that decision back and try to understand it and see whether they could improve their processes to ensure that that sort of thing doesn't happen to them.
Okay. Well, overall, what precedent could this case set for private banking and wealth management in Singapore, Adrian? Could it open the door for, more lawsuits from disgruntled clients?
Well, it really depends on the decision of the court and how the court has come to its decision. So it's not so much the final product of who wins and who loses, but really how the court's reasoning and the way that the court arrived at its decision might sort of be useful for banks and other customers to understand what their position is in law. For example, whether a bank owes a customer certain duties of care and whether those duties of care are in addition to whatever contractual obligations that a bank owes to the customer. So decisions like this, help to refine and help us to understand the scope and the nature of the bank's duties to its customers. And it really depends as well on what sort of banking transactions are taking place. Because there are certain transactions where a bank is given greater discretion and certain transactions where a bank essentially simply carries out the instructions of its client.
All right. Well, thank you so much, Adrian, for your time and your insights today.
Thanks for having me.
Thank you so much. That was Adrian Wee, who's a managing partner at Lighthouse Law. This has been The Big Story with me, Hongbin Jeong.
To listen to more great interviews, download our podcasts at audio.sg or download the audio app. That's AWEDIO, audio at the App Store and Google Play.